All right, so I looked up C.R.I.S. This is the Court Registry Investment System. What is C.R.I.S? The Court Registry Investment System is an interest-bearing cash management tool administered by the Administrative Office of the U.S. Courts that provides clerks with an easy, efficient, and safe way to comply with federal requirements concerning the handling of court registry funds. What are the C.R.I.S objectives? C.R.I.S has 4 objectives listed in order of priority. Safety of principal, the overriding objective of registry cash management is to provide for the maximum protection of principal. Sufficient liquidity, adequate funds must be available to comply with all court-ordered disbursements without endangering principal by surrendering securities before maturity. Reduced administrative costs. In C.R.I.S, the registry funds are pooled to purchase Treasury securities. The pooling allows the C.R.I.S fund manager to make significantly fewer but larger transactions than would otherwise be possible. This keeps transaction costs to a minimum. Market rate earnings. The total pool of registry funds earns market rates of return. Registry funds in C.R.I.S are invested in short-term Treasury securities, thus eliminating any need for collateral. How does C.R.I.S operate? The C.R.I.S registry funds are pooled and used to purchase U.S. Treasury securities. These securities are held to maturity, and the portfolio is structured so that sufficient securities mature each week to pay out funds for all registry cases settled during the week. Funds are invested in government account series, securities under the Bureau of Public Debt's Federal Investment Program. How is money deposited with the court? Money sent to the court for deposit into the court's registry fund requires a court order. Pursuant to Local Rule 67.1, if parties want funds on deposit with the court to be placed in some form of interest-bearing instrument, C.R.I.S is the only allowable investment mechanism. CM/ECF filers should use the motion for interpleader deposit event code if the deposit relates to an interpleader action pursuant to 28 U.S.C. 1335. In all other instances, the motion to deposit funds event should be used to docket the motion. How does money get transferred to C.R.I.S? The court order must direct the transfer of the funds deposited into the court's registry fund to the Court Registry Investment System, C.R.I.S, administered by the Administrative Office of the United States Courts. The party making the deposit or transferring funds to the court's registry shall provide the order permitting the deposit or transfer on the clerk of court, the chief deputy clerk or finance manager. Money is deposited into C.R.I.S once weekly on Wednesdays. How do I get monies deposited with the court released? A court order is required to disperse funds if the disbursement includes interest earned while on deposit. IRS Form W-9 is required for each payee. Money is withdrawn from C.R.I.S once weekly on Wednesdays. After the court receives confirmation, a payment document is processed and check dispersed, normally within 1 week. Wow. 1 week. Wow, that's fast. Let's see. Cases involving retroactive sentencing. Let's see, what is that? Order of appointment for First Step Act. Order of appointment regarding the decision in Simmons internal procedures. Order of appointment. Order governing motions. Internal procedures for First Step of Act. Order of appointment for First Act. Let me just see what that says. In the middle, in the United States District. Appointment of counsel in cases potentially involving retroactive application of the Fair Sentencing Act. Order pursuant of the provisions of Criminal Justice Act, Title 18, 3006A1, the Office of Federal Public Defender for the Middle District of North Carolina is hereby appointed to represent any defendant previously determined to have been entitled to appointment of counsel or who is now indigent and who files a motion seeking retroactive application of the Fair Sentencing Act of 2010 pursuant to Section 404 of the First Step Act, whose name appears on lists supplied by the United States Sentencing Commission or the U.S. Probation Office as potentially affected by Section 404 of the First Step Act, who has been identified by the Federal Public Defender's Office for the Middle District of North Carolina as being potentially affected. This appointment is for the limited purpose of providing general information to such defendants regarding Section 404. In addition, the court will enter a separate order appointing counsel for purposes of pursuing relief under Section 404 of the First Step Act in each individual case for any defendant whose name appears on lists supplied by the United States Sentencing Commission or the U.S. Probation Office as potentially affected by Section 404 of the First Step Act, whose name appears on lists supplied to the clerk's office by the Federal Public Defender's Office for the Middle District of North Carolina, as being potentially affected by Section 404 of the First Step Act, who files a motion seeking relief pursuant to Section 404 of the First Step Act if the court determines that appointment of counsel would be appropriate to the proceedings or in the interests of justice. The court will appoint the Federal Public Defender's Office in each such case, but the Federal Public Defender's Office may move for substitution of counsel if necessary in a particular case. This appointment includes filing a motion and pursuing any relief that would be warranted or appropriate in connection with the motion. The clerk's office and the U.S. Probation Office for the Middle District of North Carolina are authorized to disclose presentence investigation reports and statements of reasons to the Federal Public Defender's Office for any such defendant included in this order. The Federal Public Defender's Office shall provide the presentence investigation reports and statements of reason to any subsequently appointed or retained counsel. The U.S. Probation Office shall also provide copies of the pre-sentence investigation reports and statements of reasons in these cases to the Office of the U.S. Attorney for the Middle District of North Carolina. In accordance with the policy of the Federal Bureau of Prisons, pre-sentence investigation reports shall not be provided to inmates. Any recalculation worksheets or supplemental reports created by the U.S. probation officer. Oh. Did it stop? I lost it. I don't know where it is, folks. Stop. Whew.